Fast food. When it comes to fast food, what you see isn't always what you get. In recent years, there has been a flurry of cases involving false marketing claims against the big companies. Many of the charges focus on the quantity of food versus what's advertised. Karina Mitchell reports on the fast food fracas.
Some customers are accusing Burger King of making a whopper of a claim. The burger chain is the latest in a string of fast food establishments to be hit with class action lawsuits, many citing claims of false advertising. At a time when prices are rising and portions are shrinking at some eateries due to inflation, one marketing professor says she's not surprised at the increased litigation.
There is a gap between what the consumer expects, and correctly so, and what the consumer gets, which leads to consumer outrage, particularly since it appears to be deceptive.
A Florida federal judge recently ruled that Burger King must defend itself against allegations that its depiction of its Whopper burgers in store is actually about 35% larger and looks like it contains more meat than the original product, considered misleading to consumers.
Burger King denied the claims, calling them false, and said it doesn't have to serve burgers that look, quote, exactly like the picture. We asked fast food goers what they think.
It's not fair.
You expect to get what you see, don't you? Yeah. And you don't always get that.
It's not that bother me because I know it's gonna be like that. So it's like I'm used to it, but because I understand it's like a marketing.
While in the court of public opinion, the jury may be out as to whether advertising used by fast food restaurants actually amounts to deception. In the court of law, rulings have swung both ways. Taco Bell is facing a lawsuit claiming its Crunchwraps and Mexican pizzas contain about half the filling that's advertised. But most recently, McDonald's and Wendy's won a lawsuit in New York federal court, the judge citing in his decision that there is no proof the chains exaggerated their sandwich sizes and are under no legal obligation to even advertise their burgers in order to sell them. Still, with fast food chains finding themselves in the crosshairs of a growing number of lawsuits for a variety of reasons, Raghuveer says it's in their interest to change some advertising practices or risk losing customers.
It should resemble what you were advertised and what you came in to buy. Now, I'm not saying make your advertising ugly. That would be a silly thing to do. But at least aspire to the kind of images you say you are selling.
Karina Mitchell, CGTN, New York.
Class action lawsuits against food and beverage companies have been growing steadily, reaching a peak of 331 cases in 2021, many of them filed by just one New York attorney, Spencer Sheehan, and most of them reaching settlement rather than going to trial. Sheehan says he wants companies to market their products honestly, but judges in the New York state have now threatened him with sanctions, and he's been warned multiple times against bringing unserious lawsuits to court. For more on this fast food debate, we're joined by Pooja Nair. She's the chair of the food and beverage practice and partner at Ervin Cohen and Jessup LLP. Good to see you. Welcome to the show. First, let me get a definition of what truly is misleading advertising.
So the standard in the United States for misleading advertising is on whether a claim would be deceptive to a reasonable consumer, which means that the reasonable consumer would purchase a product that they would not otherwise purchase because of something deceptive or false or misleading in an advertising claim. And a claim can be what's listed on a box for packaged food, or what's in an advertisement, or even what's in social media about a product that's promoted by a company.
I mean, let's just say McDonald's showed a picture of a big giant hamburger, and I go and buy it, and maybe it's not as big as I thought it was going to be. I mean, I don't really have any loss necessarily. I mean, there's no financial loss from my perspective. I mean, what are these companies or individuals, I guess, on the class action side suing for?
Well, it's an interesting because it's part of the economics of why people sue, right? And so I'm a defense attorney. I represent food and beverage companies that are sometimes targeted by these false advertising class action lawsuits. And what's interesting is when you look at the settlements, at the outcome of the settlements, for the most part, the plaintiffs or the actual consumers get very little. A lot of the amount of money that comes into the settlements goes straight to the law firms, into legal fees, and not to the end consumers, who often will just get a small gift card or a small settlement payment and just pennies on the pennies, if not less, on the dollar for the settlement amount.
I guess my concern is there are serious cases where companies do mislead individuals and the folks they are targeting. And I feel like the fast food case, we all know it's fast food. I mean, that should say enough on what to expect from them. But in general, your take on some of these cases essentially now getting dismissed, I assume that's a win for the companies, and that at least from their defense perspective.
Yes, absolutely. And I think I think the courts in New York and in California at some levels are starting to see such an influx of these cases that they are amenable to dismissing cases that don't meet a serious standard. So, I mean, in 1998, the standard for reasonable consumer changed significantly. Before, it was really whether something on the box or very clearly on the product was wrong. But because we have FDA rules that require all ingredients to be listed, it's now changed so that reasonable consumers may be defined in a different way. But we still have a huge influx of these type of lawsuits, whether or not they're serious, and they are done by just a handful of firms.
Yeah, I was going to say there are a number of other industries. I'm thinking of the car industry and the travel industry, where they promote quite the extensive lifestyle, so to speak. And I would think that these lawyers would want to focus on some of these other industries where it's much more obvious of the damage and financial damage that have occurred to these individuals. Why are they focusing on fast food?
So I actually think they're focusing on food and beverage in general, and it's just this year that they've targeted fast food. But what they've done is there was a whole bunch of cases on diet soda that all ended and were dismissed a couple of years ago. So what they do is they'll take different products and they'll basically write one complaint, and then they'll essentially duplicate that same complaint for every product. So for example, with the diet sodas, they targeted every single company that makes any kind of diet soda product. Before that, they targeted vanilla products. So every single kind of company that had anything to do with vanilla flavoring that wasn't using actual vanilla, but was using a flavor instead. So now it just seems like the turn of the fast food industry. And in the past, the cases haven't necessarily focused on the pictures of the advertisement, because there is no FDA rule that the photos of advertisements must be, or photos of food in advertisements must be proportional to the actual food product. And so but now these cases are kind of gaining traction. So I'm sure that next year there'll be some different type of trend, but this year the food target that they're focusing on is fast food.
Might it be possible, Pooja, that they're being targeted because they have a big bank account, and these class action litigation lawyers, I'm guessing, and please correct me if I'm wrong, they're aiming for a settlement. They're not really going to court.
Yeah, but it's interesting because I work with a lot of mid-sized companies, and a lot of those companies are more likely to settle. Whereas some of the bigger companies, like you've seen with Taco Bell and with Wendy's, they'll at least fight to the motion to dismiss stage. And so, yes, most cases, I mean, in general, most cases settle. But in these false advertising class actions, definitely most cases settle. And what they try to do, what these plaintiffs lawyers try to do, is make it past the motion to dismiss stage. And once you're there, then you have more leverage. Like the Burger King case in Florida survived the motion to dismiss case, so that gives it a lot more leverage. Whereas here, the McDonald's and Wendy's case in New York was dismissed, and that takes away the leverage and incentive to settle. So a lot of companies, even if it ultimately settles, they'll at least litigate through the motion to dismiss case and see if they can get the case dismissed on the pleadings.
Pooja, giving us a little insight on the interworkings of the world of lawyers, and I guess one lawyer suing essentially another lawyer. Appreciate your time on this. Thank you.
Thank you. Thanks for having me.